Good afternoon, ladies and gentlemen. Welcome to Dear Administrator, today's seniors and Bayshore Guest Home and Gardens. It is an honor and truly a privilege for me today to welcome my guest, Attorney at Law Bob Klingbeil, and I have seen him in action and I have understood a lot of the legal issues because he has a way of explaining it that is much more people-friendly, especially people that are not used to always dealing with the law. Can we address the issue of mental capacity after a stroke or after certain incidences, whether they be grand mal seizures or Alzheimer's or dementia? Can we touch on that?
Sure. That's another touchy area, and actually a significant portion of my practice has to do with incapacity and guardianship through the courts.
Okay.
And in the state of Florida, those issues are handled through our circuit courts, the same as lawsuits and criminal, and it's also in what we call our probate division. So there are situations where folks have not done this planning. They don't have a power of attorney, and they become incapacitated. Well, no one can touch their assets, no one can meet their needs, or they become incapacitated and they need to be moved into a facility because they can't live at home, but we don't have someone with authority to admit them, and they're not able to do it themselves. So in those cases, a petition is filed with the court asking the court to determine them to be incapacitated, and that's a fairly involved process. And if the court does find incapacity, the court will appoint a guardian to control those areas of the person's life or his or her assets that the court finds them incapable of doing themselves. And then the guardian, that guardianship goes, it is an ongoing process through the courts, monitored by the courts, reports go to the courts annually, and frankly there's expense involved in that. Sometimes it is unavoidable, okay? But many times, had the person taken the time, had the forethought to do some of this estate planning with powers of attorney and that sort of thing, healthcare surrogate, they may be incapacitated, but the persons they trust are able to manage their affairs.
Can someone also appoint a guardian should they become,
yes,
prior to becoming incapacitated?
Yes.
Let's say Mary has a diagnosis of Alzheimer's. Mary knows the progression, she knows what's going to happen. Wouldn't it be wise for Mary to make a guardianship at that time while she's still...
Well, yeah, I didn't mean to interrupt you, but yes, you can designate a, quote, pre-need guardian. It doesn't involve a court proceeding. You aren't found to be incapacitated. You're basically signing a document that says, in the event I'm ever found to be incapacitated and need a guardian, I want this person or this agency, in some cases, to serve as my guardian. You know, and I must tell you that even in the best estate planning in the world, where the person has done these documents, the will, the power of attorney, there are still instances where we need to go to court to have them determined incapacitated. It may be where the person that they named power of attorney is misusing the power of attorney, perhaps exploiting, pulling their assets for themselves, or is refusing to act, or is just in general ignoring the situation. In those cases, well, they've done the best they could while they were had capacity, and yet the plan didn't work. There are other times where, unfortunately, the cases of dementia or in Alzheimer's, where the person, they become unmanageable. That's not the greatest word to use, but they just won't make good decisions for themselves. And with a power of attorney or a healthcare surrogate, as long as the person can often override them, and even though that person's trying to do the best they can, if the person who gave the power is refusing care, refusing placement, or whatever, it may still be necessary to go to court, because whereas those documents, the attorney in fact and the healthcare surrogate can certainly act in their best interest, they can't really act contrary to actions that are being taken by what we call the principal, the person. Whereas a guardian, if a guardian's appointed, the rights have been removed from the individual and given to the guardian. And so even if Aunt Mary doesn't want to go into the assisted living facility, the guardian can say, well, you have to, and can admit that person.
Thank you, Bob. And you do see people, they can come to you and you walk them through the whole process,
Yeah,
A to
that.
Z,
Mm-hmm.
and you explain it very, very well. I'm amazed.
Thank you. And I very often get calls from a family member when the crisis has begun.
Yes.
And I'm happy to help those people too, even if it does involve guardianship. If we have to go that route, I call it the avenue of last resort.
Yes. Yes.
Because the person's rights are removed, and it is expensive. It's an ongoing court proceeding versus the voluntary stuff that you may have done ahead of time.
But you're a great advocate for family and for elderly. I mean, you really are.
Very much
And
so.
I think that if you could find a way to even have counseling or something if they're opposing parties, that would be your avenue rather
Yeah.
than just immediately stop.
Yeah, and part of our guardianship law is, and it's specifically in the statute, even if the judge finds the person incapacitated, the judge must consider whether there are less restrictive alternatives to guardianship. And we've worked some different things out where even though they found incapacitated, and I indicated earlier that invalidates the power of attorney, by specific court order, there's been no malfeasance by that attorney. In fact, the court says, well, let's let the attorney in fact continue to manage the assets outside guardianship.
And you have done lots of guardianships.
Yeah, quite
You're
a few.
very well known. We have friends in common we didn't know we had.
Yeah.
Tessie.
Yep.
She speaks highly of you. Well, thank you. I
You're welcome.
appreciate this. It
nice to
really,
talk with
I've
you.
learned a lot.
My name is Bob Klingbeil. I'm an attorney in Venice, Florida. Our office is at 341 West Venice Avenue in downtown Venice. We're across from the post office. Telephone is 941-485-2900. And we also have a web page at www.k-r-law.com.
Thank you, ladies and gentlemen, for watching today's Seniors, Bayshore Guest Home and Gardens, and Dear Administrator. And please read the column and take to heart what Bob has said, because I have been privy to a lot of things where an ounce of prevention is worth a pound of cure. Have a wonderful day.